Welcome to Next Round with the Pacific Research Institute. I'm your host, Romina Ichon. In this podcast, Tim Anaya, PRI Senior Director of Communications, and I chat with Joseph Tartakovsky, a PRI adjunct fellow and an associate with the law firm Gibson Dunn. Joseph's been involved in a very fascinating case, Martin versus the City of Boise. It involved 5 homeless people who sued Boise, Idaho, for fining them for violating a city ordinance prohibiting them from living in the streets. The homeless people are also suing because they believe Boise violated the cruel and unusual clause of the 8th Amendment. This case is relevant to California because our own homeless problem, which is magnitudes larger than Boise, that even the Los Angeles City Council filed an amicus brief in support of Boise. Thanks for listening to this important legal issue. Welcome to PRI's Next Round podcast, Joseph.
Thank you so much for having me.
Well, let's begin with the case Martin versus City of Boise. So Robert Martin and several other homeless people challenged Boise's ability to fine them for violating the city's anti-camping ordinance and the 8th Amendment's cruel and unusual punishment clause. Could you briefly walk our listeners through the case and talk about why it's relevant to the homelessness crisis here in California?
Sure. This case began about a decade ago in Boise, Idaho. There were a few individuals that had been essentially received tickets for camping in public. And camping means sort of sleeping, living on a semi-permanent basis in public. And Robert Martin and a few others sued, arguing that this violated the 8th Amendment's cruel and unusual punishments clause. And they won in the Ninth Circuit. The Ninth Circuit is the federal appeals court that covers most of the western states. So the decision out of Boise, Idaho is binding on the rest of the country. And what the court said, and it's the only federal appeals court to say so, is that a city may not arrest or ticket or prosecute someone for camping, living in public, unless that person has a shelter to go to provided by the city. And this was an astonishing decision to most cities and to many people. And it comes right smack in the middle of this homelessness crisis, which has now become the preeminent concern for most Californians when polled.
So what would the practical impact of that ruling be? And what do you think is the future of the case after the news that we received about the Supreme Court just before Christmas?
Well, the practical impact is this. It says that a city can't do anything unless it provides shelter for all the homeless individuals in its jurisdiction. As a practical matter, that's an impossible standard for most cities. Either the city doesn't have enough shelter for its homeless or is unable to build it. And even the cities with substantial resources like Los Angeles. So that's the case for most small cities. They maybe have a shelter and it gets full pretty fast. Or for larger cities like Los Angeles, there's no way, no matter how many billions of dollars they had, that they could build shelter fast enough. So the practical result of the decision is to create a constitutional right to camp on the street. One of the crucial aspects of the decision is that it wasn't just about the dispute between the parties in Boise, but the court issued a sweeping decision as a matter of constitutional law, which means that it's binding on all cities, all states for all time.
That's interesting to me because, you know, I'm not a lawyer, so I'm just curious. Say I park my car at some area in the street that, you know, I'm not allowed to because, gosh, San Francisco doesn't have enough parking structures. Isn't that a similar case? I'm not allowed to do that. I'm going to get a big fat fine, probably a couple $100s. How do you relate that to what the court decided?
Well, you may not be a lawyer, but your intuition is correct. I mean, what you've identified is one of the points we've made in the case, which is that the court basically said that there's a sort of, that a law is invalid if it's impossible or very difficult for people to comply with. But traditionally, impossibility has been a defense to a prosecution in individual cases. I'm not aware of any court saying, like the Martin court, that a law itself can be struck down because it imposes impossible requirements. And that is true in this case in particular. Although for many people living on the street, they have no place to go, that's not always true. And Exhibit A is the named plaintiff in the Martin case itself. Robert Martin had a home, it turned out, in another part of Idaho. But when he came to Boise to visit friends and family, he was homeless. Now, I don't know why that is, whether he had no money to rent a hotel or a motel, or he found it convenient, or whatever it may be. But he was only homeless in Boise because he was traveling to Boise. So would it be impossible for him not to sleep on the streets of Boise? I don't think so. Not in the sense that impossibility has always meant in the law. Or to give you another example, it turns out that after the Martin decision, homeless individuals in Reno have started, according to officials there, keeping pets because the shelter there does not allow pets. And so they've been taking the position when police approach them that they have to go to the shelter or get a ticket. They say, well, I can't be forced to go to the shelter because I'm not allowed into the shelter with my pet, and therefore it's essentially impossible for me to access that shelter. Now, is that a proper application of the doctrine of impossibility? No, I don't think so.
Well, it's ironic that Idaho's homeless population is really just a fraction of California's. I read that it was about 1,000 to 2,000 homeless people, and Boise countered that they believe that they could actually solve their homeless problem with their population size. In Los Angeles alone, there are 36,000 homeless people. The problem has become a humanitarian crisis. So how can we manage this and what to do given this new ruling?
One of the things that people have misunderstood about the decision is that it didn't simply say that you shouldn't prosecute people for being homeless, or you shouldn't prosecute people when they have no place to go. That's actually something that strikes many people as fair. And in fact, in the course of litigating this case, I've been in contact with dozens and dozens of cities. I have not encountered a city yet that has a policy of simply prosecuting people for living on the street. What the decision did, far more controversially, is that it said that there can be all sorts of reasons why a shelter could be inadequate. In other words, you can't just look at the number of people in the street and the number of beds available. There could be specific reasons why someone may not be able to go to the shelter. For instance, the shelter may have a religious affiliation and the person may not feel comfortable there. Or maybe the person is not allowed to go there. Say there's one shelter in town, but the person's not allowed to go there because he's been kicked out for fighting there repeatedly. Other cities have encountered a problem where people refuse to go to shelters, and they are not sure if they can force by giving a ticket unless they go to the shelter if the person has, say, a pet, if the shelter doesn't allow pets. Or say it's a male-only or female-only shelter, and they're a couple, and they refuse to go for that reason. So the decision has tied the hands of cities across the West. No one knows quite what to make of it. And cities have reacted in different ways. So some of them have just thrown up their hands and said, well, we're not, the city court said we can't do anything about it. So until we build shelter, we may never build shelter. We're not allowed to do anything. Some cities have continued to enforce on the theory that the decision did not mean that. There's no circumstances in which they can't, say, issue a ticket to someone for sleeping on the street in a place that's not permitted. And I think some cities are sort of developing new policies that try to strike a middle ground, saying you can camp in this place and not that place, at this time and not that time. And one of the models that's developed, which is, I think, a direct result of this, is forcing cities to create, sometimes they're called red zones or containment zones, but they're essentially skid rows. They are areas set aside, like vacant parking lots, where they say you can put your tents here. Sometimes they'll provide water or some sanitary facilities, and they're essentially creating little skid rows on the theory that you cannot have sort of an unregulated right to camp anywhere at any time. And we're not going to build a shelter, and we can't afford a shelter, but you can go here. Now, that may be a sort of short-term solution, but obviously it creates problems because you're creating miniature skid rows across the state, which are bad for many reasons, but preeminent among them is it's bad for the people that have to live in it because they're often hotbeds for disease and criminality and other problems.
The city of Los Angeles, shockingly, decided to throw its political weight behind this issue by supporting Boise with an amicus brief. So what were some of the city's arguments in this case?
I think Los Angeles joined this decision because they know what life is like under Martin. As it happens, the Martin decision actually revived an earlier decision, also by the Ninth Circuit, that involved Los Angeles. And so another court had come to a similar decision, and then Los Angeles chose to settle the suit, which mooted the appeal and vacated the appeal. In other words, the decision was no longer law, but Los Angeles had agreed to abide by it. So Los Angeles, this sort of reasoning essentially emanated from a case out of Los Angeles, and Los Angeles knows what it's like to have to deal with essentially a rule of law. Like one of the ironic moments in the decision was that the judge who wrote the decision called out the dissent for including a picture of Los Angeles. And she said, this is, you shouldn't have included a picture of Los Angeles. The dissenting judge was trying to illustrate what a tent city looks like by having an image of Skid Row. And she said, this is in Idaho, a different city. Why are you including this picture? But actually, it was a perfectly apt picture because Los Angeles has been living under the Martin decision as a result of its settlement for about 15 years. And so cities can get a glimpse of what life is like under Martin by looking at Los Angeles' Skid Row. And as I mentioned, that's what some cities are deciding to do. They do not have the resources to build shelters, but they can't enforce their laws against camping unless they have a place for these individuals to go. So as I say, they're setting aside a parking lot for people to set up tents in. Joined it because they found they're trying to sort of reverse this.
So, Joseph, that leads me to a conversation we had last year. You had said something that I thought was very profound. You said that if homeless people were allowed to hang out on city streets as the Boise decision rules, then what is our society really saying about the homelessness? That we're actually accepting the situation, and this is the new normal. Can you expand on this for our listeners? Because we think it's very important what you said, because this really has profound consequences for public policy if we're now going to say being homeless is okay.
Yeah, the result of the decision, as they say, is to tie the hands of cities. And what you find is that most Californians are they're very compassionate on this issue. There's very little sort of blaming of the homeless for being homeless. They say that these people need help and often deserve help, and they want to help, and they just don't know, but it's just hard to know what to do. If you say that someone has a constitutional right to live on the street, the practical result is that you're saying that we don't have to help people, or that we're going to allow people to live on the streets. So there are some people that think it is essentially, it's a lifestyle choice. For a very small class of people, that may be true, but for most people, they're there either involuntarily or because they just simply can't help themselves. So I think it has a very sad result. In effect, it's not a homeless-friendly decision, this Martin case. When you walk down the streets of San Francisco, downtown, and you see people sort of writhing around in the street or screaming at a wall or, lying apparently unconscious, I'm sure that the thought that goes through most of the people walking by on the way to work is sadness and compassion. These are people. These are people that do not look like they're having a good time. These are people that need help. And this decision is going to make it even harder to help those people. One example of how the inability of cities to give tickets makes it harder in many instances to help people is in, for example, Honolulu and Los Angeles. Those cities have developed policies where if you get a ticket for doing something illegal, like camping on the street or blocking the street or urinating on the street, you can take that ticket and go to a service provider, drug and alcohol abuse, mental health, and enter a program or at least get evaluated for help and get the ticket removed instead of paying the fine. So in other words, the ticket is a way to force people to get services.
So apart from, all of these legal issues, state politicians are trying to do something to alleviate homelessness. So Governor Newsom has just introduced his 2020-2021 budget proposal, and he is proposing to lawmakers that they allocate more than $1.4 billion to a variety of state and local efforts. But much of the money earmarked on subsidies is for immediate housing and for community health care services. Reviewing the governor's proposal, what are your thoughts on his plan and approach?
Well, I haven't reviewed every aspect of it, but I feel that just from reading some of the press accounts, the spirit of it seems to be in the right place. At least I saw a quote from him at a press conference where he said that Californians have a lot of compassion for people that are homeless, but compassion doesn't mean allowing these people who are severely mentally ill or addicted to drugs from suffering alone on the street. And I thought that was exactly right. In Los Angeles, they're on pace to hit 1,000 homeless dead this year, by which there are going to be 1,000 deaths on the street, and often it's just the city finding bodies at bus stops or on hillsides or by freeways. This is like 3 or 4 people a day that are just dying. And they're dying because they never see a doctor, because they live without shelter, meaning exposed to the conditions. They live under conditions of violence. There's no one to help them. They live under severe stress. They don't sleep well. They're malnourished. And we should find that situation intolerable. The Martin decision says that the status quo is actually sort of constitutionally mandated. So I think that the Governor Newsom's onto something insofar as homelessness is as complex, I think, as human nature itself. I mean, there's a million reasons why someone may be on the street. Sometimes it may be by choice, but more often it's losing a home, bad diagnosis, losing family, a drug, bad luck. There's a million reasons. And so the solution has to be just as multifaceted. That could be, there certainly is a role for law enforcement, but there's also a role for building housing and mental health services. So to the extent that it has sort of different facets, I think that's good, although I think people in California will generally feel that throwing money at the problem is not the solution. But in my own view, I think that getting people connected with services is critical. It turns out that the people who are on the street because they have simply lost a job and they missed a paycheck and fell behind on the rent, these people are usually, according to the statistics I've seen, off the streets within 6 months. The people that are really driving the sense of crisis, people that when you poll Californians and 90% of them say that homelessness is the biggest issue, this is a small class of the homeless, but they're the ones causing most of the problems for the cities and for communities and taking up most of the resources. And these are the people that are mentally ill or on drugs or both. And they're responsible for most of the calls to the police. They're the people acting out on the street that that hurt commercial districts or that scare mothers taking their kids to school. And these people need to be connected with drug abuse and mental health counselors. And so I think that ought to be a major focus. Now, law enforcement can also be helpful in getting them to these services, but law enforcement can be assisted by social workers that ride along with the officers. They had a program like this in Nevada where I used to work. Social service counselors or nurses could go with police officers. They would know the individuals that they were encountering, and they could do things like make sure they've taken their medication or figure out how they can get medication, things like that. This is the compassionate approach, but it's also the effective approach.
Let's go into the legal issues of the ability of government to force homeless people into shelters or force them into going into rehabilitation programs. The law is kind of fuzzy there, and people aren't sure. I mean, when you think about someone who is mentally ill, they can't possibly make appropriate decisions for themselves, and yet some, civil libertarians say, well, they should be allowed to do what they want, and we can't force them into, any kind of shelter or any specific program. Could you discuss these laws, and has there been any move to reform them, perhaps in other states?
It's a really difficult question because there has to be a balance between an individual's rights and the rights of society to protect itself and to help those people when they can't help themselves. It really comes down to how mentally ill they are. You have a right to be eccentric or weird or even a little bit crazy. There was a case in the Supreme Court this year about whether the constitutionality of the insanity defense. And some members of the court talking during the arguments about how, by some estimates, 10% of Americans have some form of mental illness. But the question there was, can you be absolved of crime if you're mentally ill? And it sort of actually requires you to be quite incapacitated. So there has to be a balance, Rock. And I think that everyone has realized that the balance has been struck too far in favor of individual rights, by which I mean sense that, only under the most extreme circumstances should someone be restrained of their liberty. I think that there's a good solution, although we're going to see how it works because it's sort of an experiment right now. In California, something called Senate Bill 1045 has been law since late 2018. What this said is that San Francisco, Los Angeles, and San Diego counties can choose to adopt procedures that would do the following. If you are a person that has been involuntarily committed, and to do that, you have to pose an immediate threat to yourself or others. If this has happened to you 8 times or more, the police can pick you up and involuntarily commit you much more easily. To me, that makes a lot of sense. I mean, it depends on the implementation, but if you've been involuntarily committed, and this requires a court order in most instances, 8 times, you've proven that you are unable to take care of yourself. You pose danger to yourself or others. And the law, it doesn't say take the person and throw them in the slammer. It says get them to services. I mean, these are the people that, are ranting in the streets or throwing things or people running across highways, these types of people. It should be easier, I think, to get them help, even involuntarily at that moment. It's not merely because it's safer for everyone else to have that happen, but that it's inhumane in a way to let this person suffer when it's so clear that they have no chance of ever being able to acquire this help for themselves, and when they're clearly suffering.
Most recently, the Homelessness Commission that Governor Newsom appointed with former state Senate President and now Sacramento Mayor Darrell Steinberg and Los Angeles County Supervisor Mark Ridley Thomas and a whole bunch of other officials, they just released their recommendations on what policymakers should do to address homelessness in California. And at the top of their list was a call to enact a state constitutional amendment to guarantee guarantee a right to shelter. What are your thoughts on this proposal? Do you think it would complicate, the efforts that we've been talking about to eradicate homelessness in California? And is there any, research or anecdotes from other states or localities who may have gone down this path?
As others have observed, the proposal is a little bit scarce on details, but the way I understand it is that you declare it a right to have some form of housing or shelter, and either you give cities the resources to build these things or you force them to do so by creating an ability to sue them for not doing it. The only state I know where this exists is in New York, which, as a result of a lawsuit in the 1970s, has a right to shelter. My friend Stephen Ide at the Manhattan Institute has studied this, and he thinks that this is actually a very poor model. There are very few people you encounter on the streets in Manhattan, for instance. And that's because New York City puts people in shelters, but also in hotels and motels once those shelters fill up. And so the result is that it is extremely expensive. They are boarding tens of thousands of people. He tells me that this is costing the city of New York about $3 billion a year. And he just doesn't think that cities that aren't as wealthy as Manhattan could sustain anything like this. I think he's probably right. The other concern is that when you offer a perpetual right to live free of charge in hotels, at the city or state's expense, you undermine incentives for people to seek independent living arrangements. So that's a danger there. The one thing, though, that should be clear is that the right to shelter implies a responsibility or a duty of government to enforce laws against sleeping on the street. It's sort of like, if you build it, they must go. In other words, if the housing and the shelter exist, then law enforcement will have responsibility to force people into it, including by ticketing and arrests. And that's an implication of it that I'm not sure the supporters of the Martin decision have grappled with.
So let's turn to some of your current work for PRI. You're part of a PRI team of researchers who are working on a book that'll be out later this summer on homelessness in California. Can you give our listeners a preview of coming attractions and talk about some of the issues that you'll be touching on in your book?
Yeah, well, part of the effort of the book is to reflect this sense that I think everyone is coming to share, that this is a multifaceted problem. It has the causes of homelessness are diverse. There's economic dislocations, lack of housing, drugs, untreated mental illness. All these things are causes, and the solutions are also complex. It could be, like I say, the services, building houses, preventing skid rows from developing. And so we're trying to cover all those different aspects of it. So we'll be talking about the economic causes. We'll be talking about certain policies that could have unintended consequences or certain policies that work. And then I in particular will be covering the legal aspect. One of the most unfortunate aspects for me of the Martin decision is that it is one of the first major forays, if not the first major foray by a federal appellate court into the judicialization of the issue of homelessness. It's going to turn over the realm of homelessness policy from city councils and county commissions to federal courts. And if you know anything about how the legal process works, this is a very bad outcome. Courts can be very slow. The cases are decided based on what the parties in that particular case say. You don't get a lot of input from outside sources. Courts are not flexible. Decisions can take, the Boise case being Exhibit A, can take a decade or more to resolve. And the last thing we need right now is a loss of flexibility. The last thing we need is for this issue to be constitutionalized, because it really is a policy issue. It's not a constitutional issue. And we've seen other realms of life what happens when federal courts take on a sort of supervisory role. And the result is, I think, going to be largely, in the short term, certainly it's going to be very harmful. It's going to harm the people that it's forced to help, because it's going to make it impossible for cities to act. It's going to take away one of the tools that is necessary for cities to manage this problem. And often the first victims are the people that are condemned to live in these skid row conditions or in encampment.
Yes, it's a really difficult situation. What's your view on, say, the outcome of all of this? Do you think this case will stand? And what happens with situations in other states that aren't in the Ninth Circuit? Do you think we'll get more practical resolution to this case?
Yeah, well, the one thing that's certain is that the issue is not going away, because it's a real issue and it's only getting worse. So it's the end of the line for this particular case, but there will be more cases. I think they will arise in other circuits outside of the Pacific states and soon. And maybe that will force the Supreme Court to take up the issue, particularly if there's another circuit that comes to a different conclusion about this. That tends to require the court's intervention. There are already lawsuits, and there are going to be many more as cities are now forced to sort of discover the contours of this new constitutional right that Martin has created. And so I actually do think it's going to get to the Supreme Court eventually.
So finally, for our last question, we call our podcast Next Round because PRI is based in San Francisco and just down the road from California's beautiful wine country. So we ask all of our podcast guests to provide our listeners with a beer, wine, or cocktail recommendation. And I think after all the depressing talk we've had on this podcast, we need a drink more than ever before. So after working so hard on all of these issues regarding the state's homeless problem, what do you like to drink to take the edge off?
Well, in discussing this, you feel that whatever the policy or legal outcome may be, the most important thing is to have a sense that we're all in this together as Californians, and that one test of society is how it takes care of those least able to help themselves. So my sense is that the proper drink on this occasion is just a good old-fashioned, easy to get, easy to share cold beer. You don't need to go to a bar to get it. You don't need a corkscrew to open it. Just something that can be popped open on the street and is satisfying to everyone, whether you've been unhoused for a number of years or whether you're fortunate enough to not be homeless. So I pick a beer.
Any favorites?
I like the beers put out by Bear Republic in Healdsburg, the Racer 5 IPA. I'd endorse that as the beer of choice for those interested in solving the homelessness crisis.
Thanks so much, Joseph. Very interesting interview.
Thank you.
Special thanks to our guest, Joseph Tartakovsky. If you like this episode, please tell your friends and subscribe to PRI's podcast at iTunes, Google Play, Stitcher, or TuneIn. And please do us a favor and give us 5 stars. You can also listen to our podcast on PRI's YouTube page, youtube.com/Pacific Research 1. That's the number 1. Thanks for listening. I'm Rowena Itchon. We hope you'll come back again for Next Round with PRI.